Okay, I'd like to welcome you today. I see things, old habits die hard. Former students continue to sit at the back of the room. This is the third in a series of ethics workshops that we've had at Langara here. And the goal is to provide education for the Langara community and beyond about topics in research ethics, especially cutting-edge topics. We have two presentations today. One from Aaren Ivers here, who is actually a previous student from Langara. She's now a PhD student at SFU and has worked with Ted Pallas on the topic of research confidentiality. So 2 sessions ago, we had Ted talk about research confidentiality and projects that need to be done. Aaron's work extends Professor Pallas's work in interesting ways. So I think you'll find that presentation very interesting. After that, Eugenie from University of Victoria will be here, and she will be talking about the distinction between research and quality assurance, quality improvement. Really a topical topic around here and generally. So the format is that the speakers will present for about 30 minutes, and then there will be a 10 or probably a 15-minute or so question period. We'll have a short break, and then the second speaker will come to the podium. Just before we start, he's not here, but I'd like to thank Ramon Rodrigo for setting this up, and also our videographer, Craig Macadoro, who you cannot see because he's behind the camera right now. All right, so without any further ado, please welcome Aaren Ivers, PhD student from Simon Fraser University.
Where should I stand? Here? Is this good? Okay, as you said, my name is Aaren Ivers. I'm a PhD student from Simon Fraser University. And today I'm going to talk to you about legal threats to research confidentiality. And this is some research that we've been doing at SFU, myself and Ted Pallas, who has been writing about research confidentiality for 20 years. I've not been writing about it for 20 years, but I have been working on this particular project since I was an undergraduate research assistant, putting together the sampling frame, so I've been working on this for a while. And also, it's nice to be back at Langara. I have 2 former professors here, which is a little frightening, but that's okay. I'll forgive you for showing up today. Okay, so I'll begin. So the last 2 decades have seen formalized federal ethics policies in countries such as Canada, the United States, Australia, and New Zealand. So most of the attention of these policies is paid to the researchers, and there is comparatively little attention paid to the administrations who are overseeing that research and whose resources are integral to protecting confidentiality when legal threats arise. So good research, of course, not only requires the participants to trust the researchers they're working with, it also requires that the researchers trust the administrations who are overseeing everything. So there has been several cases in Canada in which the university administrations have basically abandoned their researchers. So today, Canada's federal ethics policy states that university administrations must support the researchers, and this support must be through independent legal counsel. They further encourage them to have policies in place that articulate how they will provide this support. So professional associations in most disciplines, from psychology to health, of course, list confidentiality as one of the most important principles of ethics. In the case of lawyers and clients, communications that take place between those individuals are protected by categorical protections, so they do not have to be disclosed in the court of law. Of course, for researchers and research participants, there is a professional duty to maintain confidentiality, but no such categorical protections exist. So what this means, if you want to establish the privilege of communications between the researcher and the research participant, you must do this by going to court. And of course, that is not a place where a lot of researchers aspire to be. So I'm going to go through a little bit of the history and legal threats to confidentiality and try and put this in the context of institutional obligations under the TCPS 2, just so. And hopefully you'll find something interesting in here and relevant to whatever sort of institution that you're at. So in Canada, it is rare that a third party has asked the courts to force a researcher to turn over confidential information. So there are only 4 known cases in Canada, but I should point out, we only know about these 4 cases because the researchers resisted the request. If the police came and asked them for something and they gave it to them, that could have happened hundreds of times. We have no idea. So the 4 researchers who did resist that we know of are all right here. So in each of these cases, the researchers had promised the participants that their participation would be completely confidential. So this was outlined in their protocols. This was approved by their REBs before they started collecting their data. Excuse me. So the first case was that of Russell Ogden. He was an MA student from Simon Fraser University. His research contained interviews with people who had participated or been involved in the euthanasia of people who were ill with HIV or AIDS. So this is at a time when that was a very controversial subject. And at the time, SFU was very happy to bring him out to talk, bring Ogden out to talk to the press. He was one of the few people actually researching assisted suicide at the time. So SFU was quite pleased with all the accolades they were receiving. However, when the research was subpoenaed by the Vancouver coroner, and he was hoping to figure out the identity of an unknown female suspected of ending her own life with the aid of a physician. So they wanted that information from Ogden. Lacking the categorical protections that I was talking about, his case relied on him meeting the common law vehicle for establishing privilege, which is the Wigmore Criteria. So in this case, the judge found he had met the criteria. His data was kept confidential. So the next case was that of Bruckert and Perrant. This is 20 years later. So in this case, the police were interested in transcripts from a prostitution study. They were informed that there was an interview in there with Luca Magnotta, who was at the center of a pretty high-profile manhunt at the time. And it was through no fault of their own. They took all the right precautions to protect the confidentiality of their participants in this prostitution study. Had been a former research assistant of theirs who had seen his face on the news and relayed that to the police and said, this guy was in our study 5 years ago. He used the pseudonym Jimmy, so of course the police wanted the transcripts. Like Ogden, they also did not want to give up this confidential data. They also went to court. They also invoked the Wigmore Criteria, and they were also successful. So the third case was Greta Bauer from Western, and she conducted research on transgender individuals and was planning on being an expert witness for the Center for Gender Advocacy when they were challenging Quebec's rules as to how and when transgender people could change their genders on official government documents. So because of her role as an expert witness, this opened the door to the defendant's counsel to say, we want your research data and we don't want a redacted version, we want everything. So of course she did not want to comply with this. She also went to court, invoked Wigmore, was successful. And the fourth case in Canada, my French is terrible, but Marie-Eve Maillet, it's not, Maillet, does that sound close enough? Okay. She was, of all things, had been doing research into a windmill farm. So she'd interviewed residents from the surrounding area about their thoughts and feelings about the windmill farm, about their thoughts and feelings about their other neighbors, that sort of thing. When some of these community members filed a class action lawsuit against the windmill farm company, she also was going to be an expert witness. They also demanded access to her research data. So she went to court, used the Wigmore Criteria, and was successful in keeping the information confidential. So the reason I go through these is just to draw your attention to the kinds of information that's being sought. Certainly in the case of Ogden and Bruckert and Perrant, if you're working in criminology, you're always thinking about perhaps maybe the authorities are going to come asking for information. However, if you look at the windmill farm data, I don't think anyone anticipated there would be any interest in this research. And this one is kind of a game changer. And as you can see also, the first two were kind of in the context of solving crimes, where the second two cases were because they were going to be expert witnesses. And because the last two cases both happened really recently, this could indicate that's something that we might be seeing more of. So we want to be vigilant against this. So basically it crosses the boundaries of any discipline and any level of sensitivity of research. It's not what you would typically think just about things related to crime. So though all of these researchers were ultimately successful in keeping their data confidential, it was not without a lot of problems. So these are situations where, you know, your reputation, your financial standing, everything is put at considerable risk. And in the case of Bruckert and Perrant, if word gets out that with the community that they've been working with, individuals involved with sex work, that they're giving information to the police, they simply won't, participants won't talk to them anymore. So the research will dry up there. So I just want to draw your attention to the response of the administrations in all of these cases, which is kind of more relevant to what we're talking about today. So in Ogden's case, SFU effectively abandoned him. They did not want to be seen as publicly supporting assisted suicide. So Ogden responded to this by suing SFU for breach of contract. He wanted to recover the $15,000 he'd spent on legal fees. And as a master's student, that's a pretty considerable amount of money. He ultimately lost his case. However, the judge was very critical of SFU. They called us hollow and timid, and they said the university had failed to meet the very standards it itself had set. So that didn't look too good, and eventually SFU wrote him a formal letter of apology and reimbursed him for his legal fees. So after the Ogden debacle, Canada's federal granting agencies introduced a Tri-Council policy statement, ethical conduct for research involving humans. And of course, this was replaced by the TCPS 2 in 2010, further revised in 2014. So as you can see in Article 5.1, institutions shall support their researchers in maintaining promises of confidentiality. And Article 5.2, researchers shall avoid being put in a position of becoming informants for the authorities. So when they released the Tri-Council policy statement, one thing that they did mention was the need to keep REBs at arm's length from the administrations. So that's a pretty important principle, and this has been with the TCPS2 since the beginning. Now, if we look at how the University of Ottawa responded to Bruckert and Perrant's case, it was almost identical to Ogden, and this was 20 years later with the policy in place. The university only gave the pair a few $100s for legal advice, and it was the Canadian Association of University Teachers who paid for their defense, which ended up being $300,000. And that's one level of court, so you can imagine that's quite a considerable amount. So in light of this, a complaint was made to the Secretariat against the University of Ottawa, claiming that they did not support their researchers because it was in fact the Canadian Association of University Teachers who had paid. And they did an investigation and they said, you're right, they actually didn't support their researchers. So what ended up happening, U of O reimbursed $150,000 back to COT. So as you can see, these institutions aren't paying in the beginning, but eventually they're having to pay anyway. Right. Okay, so after this happened, the University of Ottawa was quite clear. Their excuse was that, well, you didn't really tell us what support meant. Maybe support means a pat on the back and a good luck or something like that. So, but they came out with an interpretation which they published on their website. Now, it becomes very clear when you read the interpretation that support actually means access to independent legal counsel. Support's not a pat on the back and you're doing a good job and good luck in court. So they went a little further, and the granting agencies suggested that institutions should implement a policy to articulate how they will support their researchers. And the policy should include an explanation of the nature and scope of support, a mechanism to determine the level of support in individual cases, and the source of the funding. And I should just draw your attention to the word should here. That indicates that the policy is actually not a requirement, it is a suggestion. However, I will caution that. I was listening to Zimmerman speak not too long ago from the Secretariat, and she was saying that when you're reading the interpretations, you should be abiding by them as closely as you should be to the articles in the Tri-Council policy statement. They're just as important, but just because of the wording here, whoops, that said should. Sorry. Yes, okay, because it said should, this just means that it's not a requirement, but they strongly suggest it. Okay. So just to finish up the last two researchers, in Bauer's case, she did receive immediate support in legal representation, but this was not provided by her university. It was provided by the Center for Gender Advocacy. However, her university did come out in the press and say, we would be happy to pay for an appeal if it's necessary, so they were willing to do the right thing. Unfortunately, in the case of Maye, UQAM was nowhere to be found. She had to get a lawyer to help her pro bono, which she did. Now, it was only months later, after people started complaining and signing petitions, that UQAM came out of hiding and said, oh, okay, well, maybe we can support her too. So the main information we were after with our research, I'll come back here. So support is required, a policy is not. Why would you want to have a policy? This is a question people are asking me. So all parties fare best when access to legal advice is immediate. And although we've had the 4 cases in Canada, there's been dozens of cases in the United States. So when we look at the advice coming out of there, they all say the sooner the better. And of course, everybody likes to make fun of lawyers, but they know the law and they have good ideas and they know how to keep the participants safe within the confines of the law. And of course, assessing a researcher's need for support on a case-by-case basis invites conflict of interest, as we have seen in most of these cases. As you need an REB, independent from administration, you also shouldn't have the administration making these decisions. And finally, creating a policy sends a message to researchers that they can trust their institutions. So of course, that is important as well, especially in the light of the history of legal threats. So how widely has the admonition to develop a protection policy been followed? So we did a national survey of mostly REB chairs. We had, compiled a list of all the institutions who receive federal funding. Now, we had to eliminate the most of the French-speaking institutions in Quebec just for ease of language. But we ended up with our final sample. We had 60 REB chairs, 10 REB staff members, and 3 members of administrations. Now, all the research institutions were all different kinds. We had small little colleges in remote areas to sprawling university campuses offering PhDs with medical schools. So we had a nice mix of different kinds of institutions. And we also had good regional representation. So if you look at the dispersion of all institutions who receive federal funding from the granting agencies, we had a similar dispersion within our sample, so it was fairly representative. And finally, in an effort to maximize our chances or our likelihood of finding any policies, if the people in our sample didn't have them, we did extensive internet searches, and we actually were able to find 2 policies that way. So of course, this is the main information that we were after. Has your institution developed such policy? So as you can see, 6.8% claimed yes. 23.3% said not yet, but doing so now. 8.2%, we tried but abandoned. And over half, no, we have yet to begin. And of course, there's the people that don't know who always show up in every survey. So we did, just to draw your attention to some of these numbers, for the people who had not yet begun, so the majority of the group here, 75, the people who hadn't given it any thought for BA granting institutions, so a place like this, 75% of them had not yet begun. When we're looking at PhD granting institutions, something like SFU, you would see 50% of them have not yet begun. And universities that do have medical schools, only 15% of them had not yet begun. So the most common state of affairs is for nothing to be going on in this situation. And when we look at these 5 who claim that they did have a policy, even that is probably an overestimate. When we examined the policies, they, for the most part, did not meet the criteria as set out by PRE, which I'll just remind you, requires a complete explanation of the nature of support, a means to determine the level of funding, and the source of the funding for the legal fees. So many of these, for the most part, they were just cut and paste out of the Tri-Council policy, or they simply stated, we will assess this on a case-by-case basis. So, which of course, case-by-case basis is not really the way that we should be doing this. And of course, universities should have every opportunity to manage their own finances and manage their own images, but we do not think an ethics policy is where that should be done. We did, however, find 2 policies that were really good. So the first is McGill University's statement concerning institutional support to researchers, maintaining promises of confidentiality. And I actually brought this, I printed these out so you can even look at them later on the break or something. And as you can see, this one is a scant page and a half. I mean, it hits all the notes, basically, that is mentioned in the interpretation. Basically, the headings are taken straight out. Nature of support provided to researchers, scope of support provided to researchers. So perhaps it is not written in legalese. It's understandable language. It's short. I think people can understand it. So maybe if other institutions had a look at this policy, it would be far less daunting because it's really not that complicated. And the second document is a bit longer. This is from the University of Waterloo, which is this one. It starts out with a little bit of the history and that sort of thing, and it goes on to say why you would need independent legal advice rather than advice from the university lawyers, because you don't want to be taking advice from the university lawyers. You want a lawyer who has your participants' best interest in mind, and by extension that would also include the researcher, but really we don't care much about the researchers. We're concerned about the participants, but the researchers are just a byproduct of that. So again, both of these clearly make that distinction of legal representation. So when we're looking at those who are currently working on policy development, as shown here, the respondents were most often from the large schools, followed by the medium schools, and the small schools. So when we look at engagement in policy development, it was positively correlated with institution size being larger, and this was statistically significant. Of course, it stands to reason then when we break it down by type instead of the size of the students, we have the PhD granting universities with the medical schools, currently working on it, hospital or medical schools, PhD granting universities. So the more bells and whistles also, the more likely they are to be a claim that they are working on a policy. So now we're going to talk about the obstacles, and this is what people are saying are impeding these policies at their institutions, and you can decide whether you think these are good reasons or not. One of the biggest obstacles reported across the entire sample was that of an unreceptive administration. And I should point out this is not a discrete category, and as we go through some other items that are in there, they're kind of tied back to the same idea. If you look at the second comment here, I won't read it for you because you can all read, but if you look at that comment, should be very reminiscent of both Ogden and Bruckert and Perrant. This is exactly what happened. So whoever that person was, they're up on their Canadian history of legal threats to research confidentiality. Now the second impediment given was being unaware of the directive. So 41 institutions who hadn't even considered creating a policy, half of them, well, 20 of them, so almost half of them, hadn't even heard of this, which is alarming. An REB chair from a small BA granting institution stated, "We are quite a small university, relatively young. I'd suggest we're a little behind in thinking some of this through." So another respondent, and this is not limited to small institutions by any means, because we had another respondent from a large PhD granting institution with a medical school who said, "I chair one of the REBs. I don't think we've ever discussed this issue." So, and that's the chair. So another one that was another impediment that was given is that it's a rare event, thus it's not a priority. Well, of course, it's a rare event that we know of researchers resisting. We have no way of knowing how often the police are just asking for things and people are handing them over because maybe they think they're obligated to. And I think one thing we did find when we were collecting our data is that there is a lack of awareness in some institutions about exactly what their obligations are. So hopefully that'll change. So among those who had yet to begin, the 6 of them that stated it was a rare event and not a priority. Of course, priorities are set by those at the top. So again, this is tied to an unreceptive administration. Lack of guidance and an understanding of what a policy should include. So of course, many respondents were stating there's no one here who knows how to do that. Maybe there's one non-practicing lawyer who could kind of figure this out, but we don't have qualified members on our REB who want to do this or who are able to do this. And of course, the minimal risk research justification. So a lot of institutions saying, oh, we just do minimal risk, so we don't need to worry about this. Of course, if there's interest in windmills, there's interest in anything. Let's see. And of course, unclear who should be involved. So one respondent had a really good point. She said no one owns this, she or he, no one owns this issue at the institution. REBs can be the squeaky wheel that keep reminding the key institutional players, but we do not have the authority to implement this policy on our own. So again, this is tied to an unreceptive administration. So the remainder of the issues appear to be resource related. Do not have time to dedicate to such a task. Now, this was a particularly strong sentiment among people at small institutions, and I think across Canada, we've seen a trend of institutions ramping up their research. So we have places that were formerly strictly teaching institutions that are now doing research. So you have an REB that used to see maybe 3 protocols a month. Now maybe they're seeing 15, but they still have the same staff that they had before. Obviously, that's a problem. Some other things, they're requiring more research from faculty. And I know in the field of medicine, right now nurses are required to complete a lot of research in order to get their degrees. So this is, a lot of research is being increased all over Canada. And I'm wondering if the REBs are structured to keep up with the demand for all these protocols coming in. And not only that, they have to stay on top of the new interpretations coming out of the Tri-Council. And finally, financial costs. This was a big one. A senior administrator from a small BA granting institution said, in light of our size and budgetary constraints, it would be disastrous if we were faced with the obligation to support a researcher. So if you think of Bruckert and Perrant, $300,000 for one level of court, should there have been an appeal, this could have quickly gone to $1 million. Of course, they had a very expensive lawyer who was really good, but this is a significant problem that some institutions see. So of course, while there's many impediments, there are remedies, and a lot of these were suggested by the respondents themselves. So the unreceptive administration, what we're hoping is that researchers and REBs will maybe be squeaky wheels and talk to their administrations and say, what about this? What are we going to do? Do we have a plan? Because we find when institutions don't have a plan, that's when everything falls apart. So we're hoping that maybe if people are excited about this, maybe trying to participate in consultations and that sort of thing, like this kind of thing that we're doing today, just to kind of get the ball rolling, at least to start the discussion here. In terms of not knowing about the requirement, that's again why I'm here talking to everybody. There is an obligation. Your institution has to support a researcher with independent legal counsel. This is not optional, and this is very clear, and a lot of people are unaware of this for some reason. So in terms of it not being a priority, we can set people's priorities, but of course education will help with this as well. And addressing the minimal risk research justification, that doesn't hold. We know that. We've seen in the MIA case that it doesn't matter what kind of research it is. These can come out of left field. You can anticipate every request. You can do every single thing right as a researcher and as an REB. But there are things out of your control. There's loose lips and sink ships and all sorts of things that can go wrong. And impediments including staff lacking expertise, staff turnover, and a lack of guidance. Now, what a lot of people were really interested in perhaps doing here, or interested in the Secretariat doing, or the panel in research ethics, would be if they had released a basic template that would tell everyone what a policy should include and outline the main considerations that would be included in that. And this would presumably cut down on the time and effort required to put a policy together. And in relation to the resource issues for financial cost, one suggestion was a consortium of similar institutions pay into a fund. So if any researcher from any of those institutions were to get into trouble, they would all draw from this fund. So this was a really popular idea, especially among colleges. I'll throw that in since we're in a college, so, okay. And so REBs and researchers are kind of enduring this administrative inertia with respect to kind of policies coming down the outlines or coming down the pipeline, and administration's not outlining how they plan to support their researchers if such a situation did occur. So one of the current strategies, and it's kind of besides the research, but since you're all in REBs, I figured you might want to know what everybody's doing, or at least what they think they're doing to kind of help threats to confidentiality, using oral rather than written consent. This is a really good idea, and I know it varies at universities. It actually varies within departments in universities. So there are certain professors at SFU who will not allow you to take written consent. There are others who demand that you do. But I think a best practice would be to just use oral consent and get rid of the paper trail. And of course, redacting identifiers at the earliest logical stage in the research process. We don't care if they want the data as long as the people are protected. So as long as it's not tied to an individual, I think most researchers have no problem giving out their data. It's the participants we're worried about. So if you can redact those at the earliest logical stage, then that's great, and you can hand over your information and know everyone's protected. Of course, you can't do this after, or you're in big trouble. So don't do that after. And the final thing that some REBs are requiring right now is that all approved protocols are designed to be defensible via the Wigmore Criteria, which the Wigmore Criteria is here. And as you can see, one thing I will caution about, is everyone quite familiar with Wigmore? I would assume, okay. One thing I would caution you about the Wigmore Criteria is that these principles have to be taken into account in the design stage. You cannot apply these retroactively. For example, the communications must originate in a confidence. Well, it better say in your REB application that this is confidential. In your grant applications, this has to be planned before you collect your data. None of this can be done afterwards. And you have to kind of reaffirm things as you go through the process of research as well. So, good night. Everyone got that one? Okay, so researchers and REBs are clearly trying to do their part here. And perhaps it is time for the administrations to step up and fulfill their obligations as well, because it appears that legal requests for confidential data has not gone unnoticed by the participants in the survey, and a lot of them talked about fears about what it's doing to research in their institutions. We don't want to turn people off from doing research with marginalized populations and that sort of thing because they don't want to cause them any harm because they know their institutions are going to protect them. We want to encourage that kind of research, but we have to make sure that we're taking care of the participants first. So in conclusion, the research shows that institutions will summarily pocket the research dollars from the federal granting agency with giving little thought to the research participants. Sorry, am I sounding too much like Ted? I don't want to go on a tangent. But when we look at the legal threats to confidentially in Canada, while some of these requests or demands have been foreseeable, others have not been, and this is putting the privacy of any sort of research where confidentiality is important at risk. So institutions who engage in research with human participants, they need to show that they have researchers and the research participants' backs. We're not seeing this right now. Creating policies that outline the steps that you will go through to help your researchers and basically in protection of the research participants is simply good practice. So it's the obligation of all of us engaged in research, from the REBs to the researchers to the administrations as well, to work together to protect research confidentiality and, of course, more importantly, protect our research participants. Thank you. Okay.
Can you summarize the questions?
Sure.
Okay. So we have 10 or 15 minutes for questions.
Yes. Sorry. I'm just wondering whether the Tri-Council itself has taken any, if they've been involved in any discussion about whether legal insurance would be tied to funding that the universities receive for research that their faculty are doing.
Legal insurance is an option, and that is a good option. That would work, but for most of what we're seeing is it's for only faculty. It's only through a faculty association, as we have at SFU. It's not protecting all researchers.
Yeah, no, I'm just wondering if the funders have sort of discussed enforcing obligations on the institutions who receive their funding.
Oh, well.
To provide legal protection should it be needed.
Well, when the University of Ottawa, they were investigated, and I think the reason they were being investigated was to see whether they could continue to receive their funding because they hadn't supported the researchers. However, because they said you weren't clear about what support meant, they kind of left them off the hook. I don't think the granting agency is anxious to start yanking funding from big institutions, of course, but they do want to let them know that this is ultimately what can happen if you don't follow the rules. And there are people watching and people complaining to the Secretariat when institutions are not following the rules. So that is definitely something that you want to do. Yes.
Thank you very much for the talk, Aaren. It was wonderful, and you did Langara proud.
Thank you. Yay.
This is not a question, it's more of a comment. One of the options for improvement was oral versus written, consent.
Yeah.
Just to be devil's advocate, I mean, imagine in qualitative research if someone has collected 25 transcript pages of material about immigration policy or whatever the case may be. And if it's oral consent and the researcher keeps the data for 3 or 4 or 5 years, and then subsequent to their original focus or perspective, they now want to mine the data again from a different angle. And that new angle would be unacceptable to the participant. If you just have oral consent, then it becomes just he said, she said, or whatever it is. I think that eliminates the protection.
I think that's why people like to have written consent, but from our position, the benefits of written consent are far less than what they provide. I do understand what you're saying, and I mean, some institutions do require written consent. We just don't recommend it, and I don't think it's necessary. We used oral consent for all of this project, and it worked pretty well. I don't know what would happen if you wanted to go back and do something different with your data if the participant refused. I mean, if they're going to say no, then they say no, and that it's their right. It's their data, so I mean, that could happen, but you could also have a written consent and they could also change their mind. Perhaps.
Okay, thank you.
But isn't the issue that if you have oral consent, then it's going to be harder for participants to withdraw their data. So TCPS 2 requires that we consider allowing participants to withdraw their data if you have oral consent. I mean, the real issue is whether you have a link between the person's name and the data that they're giving as opposed to the consent form, it seems to me. And the safest thing would be to either not have that link or eliminate it and eliminate the name as soon as possible.
Yeah. Yep. That's another pretty good way. We just prefer no written consent.
I'm having trouble seeing how oral consent would protect the participant. I'm just
Because,
not-
the only thing is the paper trail. So if they give oral consent, their name isn't written down anywhere. So it's like the name is redacted before it's even added.
But there's still identifiable data included within the data that the researcher is collecting.
There
which,
could be.
If it was subpoenaed, could identify who the...
Well, yeah,
So-
of course, every situation is going to be different. But I mean, by taking their name off the data, well, you've already eliminated the name. So of course, in many, many cases, you can go through the data, even if the name is gone, and you can figure out who it is. That was actually the problem of Bowers. There wasn't actual names, but there was postal codes, and there was areas where people lived. And when you put all this information together, you can figure out who the individuals are. And of course, that does happen. So I'm not saying I have all the answers, but yeah, but that does happen for sure. And I think that was one of the big fears. Even if there is no name, I mean, a little investigation and you can pretty much figure it out. Yes.
Go ahead. Did someone else have a question? Oh, sorry. So just a question, isn't Wigmore, the Wigmore Criteria, aren't they part of the problem in a way? In that, so you put up the slide.
Yeah.
So the, let's see, which number there is, yeah, so number 4 has this balancing test.
Yeah.
Right? And so that's, in a way, that's an invitation to lawyers, prosecutors, to want to try to argue that there is this balancing, and it's, you know, there's more social value in disclosure than in protecting research, and that a better, you know, another path on which to work here is to define better the boundaries, categorical, you know, like the, so have you, and I know that in the US they have a couple of different instruments for protecting research that are essentially categorical. I mean,
Yes.
there's been some litigation around it, but they've done a pretty good job, I think, of protecting research confidentiality by giving pretty categorical protections.
Yes. Those are from the Department of Justice and Department of Health. Sorry, I'm not up on my American names of departments. But yeah, in the States, they have categorical protections for researchers, which we don't have in Canada. And actually, in our survey, that was a question: would you favor categorical protections for researchers in Canada? And out of all the participants, it was overwhelmingly one person said no out of 73. So it was something people were really interested in, and this is something I got a bit, I've thought about since then. However, the Wigmore criteria, we started doing this years ago, putting the sampling frame together and the questions and things. The last 2 cases were decided when I was writing my thesis. So I was revising, oh, another case has been, oh, there's another case, and oh, this is how it ended. But Wigmore has been successful. So that was certainly something that we were looking at. But Wigmore has been successful so far, so perhaps, I mean,
But it's an invitation, right?
It is.
I mean, that's too strong a way of putting it, but given that there's this balancing, and then lawyers are going to want to try to figure out, well, you know, at some point, you know, the benefit, we may successfully argue that the benefit of disclosure outweighs the cost to research. So
Yeah.
I would go to bed at night worrying about that provision if I
Do you now?
Well, I'm not a researcher, right? No, but if I was, if I was doing research on vulnerable populations that was, socially controversial, or even the wind farm case, you got to think. In that case, you might think, well, what's the when you find a judge who says, well, there's no cost, there's no harm to these individuals. I'll issue an order that there will be no disclosure of personal information, blah blah blah, and so you're relying on the sensitivity of the judicial process to make the balancing.
Right.
And we only have a couple of cases.
Yeah, and I mean, when we started this project, there had only been 2 cases, and the last 2 kind of just popped up, and then both were settled. So we opted not to include our questions regarding categorical protections for Canadian researchers, simply because Wigmore seems to be doing the job. However, I will tell you that people were really in favor of it. There was only one person who said no. So.
Thank you for your presentation. I really liked what you said about how the participants in research should also trust the researcher, and that the researcher in turn should then trust the administration.
Yes.
Have there been any reports of researchers not participating in research because they don't have their administration support?
We've heard anecdotally, and I think the last couple of comments on the last slide, yeah, there are people who are nervous, and there's people who said, I'm not participating in this kind of research at this time. And there was also people from REBs who were saying, there are protocols that we will not approve because we don't think they can adequately protect confidentiality. So, yeah, it's having an effect, definitely. I think if you look at Ogden, he is no longer in academia, so maybe he just got fed up with it. If I was one of those researchers, I would be really mad, and I think it would color the rest of your research years. You would always think in the back of your mind, and of course, me studying this for a few years now, I'm always thinking that as well. You don't want to be constantly worried, and that, of course, that's not our intention here, but our intention is to draw you to the fact that maybe you should be a little worried. But of course, talk to your administrations, see what they're doing to protect the people. Yes?
Thank you for your presentation. You mentioned 2 universities that have developed policies. McGill and University of Waterloo.
Yeah.
When did they implement those policies? Do you know the timing?
I do not know, but I know Ted had given a talk, and this second one that we found actually it almost is like they read Ted's book. So it talks a lot about the history and things like that. So I think maybe part of us getting out and presenting and talking to people, I'm pretty sure they were pretty inspired by Ted here. I don't know where they came across him or how, but clearly they do mention the history, and they also mention the book, and which he wrote for, was it the Canadian? The Canadian Association of University Teachers. So, yeah, I think this is like a recent development. This must have come out. I can't imagine it's been out for more than 6 months.
Is there a date in there?
I don't see. 14, January, February 14, 2017. This one does not have a date. But yeah, so that's all we found. And also we did not find these actually from our sample, so we're not ruining the confidentiality of all the individuals who participated. These are online, and you can take a look at them if you want later.
Okay. All right, well, thank you very much, Aaren.
Thank you.
Thank you.
We'll start the second half of the presentation with Eugenie Lam from the REB at the University of Victoria. I've said a little bit about Eugenie. I've invited her to say a little bit more, but without any further ado, we'll start the second half of the program.
Yeah, thanks. Yeah. Yeah, thank you for the invitation. I love coming back to Vancouver. I grew up here, and it's great to come across the pond and have to actually drive 10 kilometers faster all the time. So just a little bit about myself. I've worked at the UVic Research Ethics Office since about 2005. And those were very early days, because just in the late 1990s, UVic had a research ethics review committee. It was called a committee at that time, and I think it consisted of one chair and a half-time clerical person and maybe some board members. And I was talking with my colleagues here from UBC, and we were talking about how still in some ways, as busy as the REB offices get, we can generally never keep up on the number of applications flooding in. So, you know, a lot has happened, and today I'm really happy to share with you some of the experiences that we've had at UVic in, I guess I would call it, trying to understand the relationship between quality assurance, quality improvement activities, and research involving humans. And we're still trying to understand, and it's a relationship. And thankfully, the REB office is not the only institutional player in this, because we would not be able to actually do what we normally have to do and try to address other institutional, and by institutional, I mean academic, administrative, and planning areas that come into play when we talk about this relationship. So I think this is usually how people in REB offices feel when you pick up the phone or someone emails you and they say, "Oh, I have a really quick question." I have a really quick question. And this is where we often find ourselves. And I'm just wondering if you could, with a show of hands, do you often find yourself in that kind of divergent, do I go this way, do I go that way? So it's really been for UVic what I would call the road trip that has no map. And we're trying to kind of map it out. And I think in preparing this presentation, when you look back on something, then you've kind of created a map in retrospective. So that's what I'm going to present today. What are some of the things that we learned? What are some of the things that different levels of the institution tried to do and are trying to do in order to grapple and get an understanding about these two kinds of animals or activities that happen within universities? Okay. So just to lay out some objectives for today, I will present some assumptions and conditions. And the limitations of the presentation are that I'm going to be presenting this information from the perspective of someone who works in an REB office. I'm not presenting it as an expert in quality assurance, program evaluation, in that area, but it's someone with this REB lens. And when we look out and we try to understand what is that other activity, how does it relate to what the REB's mandate is, and where are the gaps, and where are the confusions? Lots of confusions. I'll just tell a story as well about sort of where we started from with some policies and guidelines that sort of gives an architectural structure to the institution's perspective. I'll talk about some of the key institutional players and their roles in this initiative, and I guess why in this talk I'm going to try to think about QA and QI and research not as discrete categories, and why and how it is that they don't operate discreetly, especially within a post-secondary university context. And I'll provide some examples for that. And then at the end, if you're one of my overworked, busy colleagues in REB offices, just some guiding thoughts. And I would really like to hear any stories or insights that you would like to share with this group as well. So I'm hoping to raise lots of questions. I may not have firm answers on this. Okay, so here are some institutional assumptions and conditions. And I guess to frame this, these are my assumptions about the institution's assumptions about the activities that happen there. And here's the first assumption within a university context. Mostly anything can be studied. And I've purposefully not used the word research here because I want to emphasize that there's actually an overlap between QA, QI, and research. So anything can be studied, and the reasons for that is that post-secondary institutions reward. They provide academic rewards, they grant degrees, people study things in order to improve society, to create social change, and for intellectual curiosity. So that's the first assumption. Okay, this is the second assumption. Anything can and should be improved. So in a large institution, we generally look at what I would call our practices. Whether or not those practices are learning outcomes of students, student performance, we revise and refine curricula and program. We look at ways to attract the best and brightest faculty in certain areas. We produce strategic plans. All of those activities are expected of large institutions, especially ones that are publicly funded. Okay. So this is the last part of my musings here. Anything that is studied can also be improved by the studying of it. I think this is where the yes and the no signs tend to converge. And this is where I think it's very difficult to completely separate quality assurance and research. Okay, I don't want to load you down with definitions of research, but I think it's a good place to start because in these two definitions, one is from the TCPS 2, and one was actually from a memo that I found in the vice president sort of research area. And it's very interesting because both of these definitions actually use the word intent or intentions. So they're pointing at purpose. The purpose of research is to do these things. How many of you, when you see these definitions of research, how many of you find that they're useful when someone brings to you the question of, is this quality assurance or research? Yeah.
It's a good place to start.
Yeah. Okay. So our VP research was quite involved in trying to figure out this quandary in I think it was about 2003. So these parts of memos actually pointed, I sort of started to illuminate some things that we had been thinking about at UVic afterwards. So of course, with the top one, there was a recognition that quality assurance and assessment and research often use the same kinds of approaches or methods, but the intended purposes are different. They may not be equivalent. And the second one here is really about decision making. Again, the purpose is to help to make decisions to develop or assess programs or services. So unfortunately, the person who wrote this is now no longer at UVic. Otherwise, I think I should have asked them to come and co-present with me. Okay. I'm always relieved when I find something in the TCPS2 that suddenly speaks to institutional quandaries. And this one small article in the TCPS2 made me start to feel like, okay, perhaps this thinking about QA and research kind of opens up. It opens up the door to trying to understand the relationship. And so here I've emphasized what is not considered research involving humans according to the TCPS2. And it is when you're conducting these activities and they are going to be used exclusively for the purposes of assessing, managing, and improving things. So keep that in mind when used exclusively, because when we take those words and we overlay that into an institutional context, things kind of explode in lots of different directions. Okay, so a little bit about a story here. In about 2003, there was a process that the VP Research Office started, and that was to develop a policy at UVic, which they called, and I always think this is a very unfortunate name looking back on it, Ethical Assessment of the Institutional Quality of Programs and Services. As far back as 2003, UVic recognized that there was a lot of confusion about what kinds of activities constituted research involving humans. And for those activities that were QA or QI, what did the institution expect? What kinds of conduct, ethical conduct, were should be in place in order to conduct program evaluation, if that's what you were doing? And then if we fast forward recently to 2015, a new process took over to actually revise those 2004 policies. And that's when we realized that the 2004 policy really needed to expand and also be specific. And the key dilemma here is that at least within the institution, research ethics, as we know, it's a regulated activity. It's highly regulated. There's a research ethics board, an office who look after this whole process. At least within UVic, there is no and was no centralized place for people to go if they said that they were doing quality assurance. So we're dealing with very uneven territory here. And the fact that, of course, as we know, in research ethics, the approval and review is non-retroactive, and it's based fully on voluntary participation. So we needed to get clear so that people weren't going down the wrong path and then knocking on our door of the REB and saying, help us, because we didn't know, which way to go. So the people who contributed to the first policy as well as the second, these were the players. They were the president's office at UVic, the privacy office, another office called the Institutional Analysis and Planning, and I think at Langara you call it Institutional Research. So those are the people who I sort of call the big number crunchers down the hall. We share the hallway with these people, and they roll up huge databases that with that information that is shared within the university for strategic planning, and it's also communicated out to BC ministries and other national level organizations. And then you had the REB chair, and I was involved in that 2015 process. Okay, just a snapshot here about what was different between these two documents. So the first document was really trying to focus on creating ethical standards for QA and QI and any activities that were not covered by the TCPS2. Interestingly, in this document, it refers to people as participants, which I found was quite confusing at the time. And it made an attempt to distinguish between the QA and research activities. And I do remember when I first started working in the REB office, I would mull over this policy, trying to understand how I could apply it when we were trying to figure out if a project really was quality assurance or research. That document actually is no longer available on UVic's Board of Governors internet, but I have a paper copy of it. And the home base of this policy was the President's office, because it was trying to anticipate and provide guidance about if you were doing a QI or program assessment, what you should do, how you should do it. But the key thing was that you actually needed to get approval to do it. And those approving positions were the chair of a department, a dean, but also the director of institutional analysis and planning. And interestingly enough, it had also writing that said, for activities that border on research, people were to then also contact the chair of the ethics board. So before that policy got revised, it was interesting because I talked to the director of institutional analysis and planning, and I asked him, did anyone ever contact you in those 11 years when this policy was in place to get your approval to do something that was, program assessment? And he basically said no. And so from that point, I realized that it was actually, that document was the document that the REB office was using, and we were the ones who were interpreting that policy for the university. So it was, it was a bit of a wake-up call as well, and also informing us that, okay, there's a role here for the REB office. Maybe it wasn't a role that we created for ourselves, but it was a role nonetheless. So in 2015, when pretty much the same institutional players came around the table, we learned what we needed to, and we changed a lot of the language. We didn't want to call people at the university participants. We called them respondents because they were responding to questions or surveys or interviews about their programs. And we also put in a much better distinction between these two activities so that it would be clearer for our office, but also for people looking at these guidelines. And then in the process of developing them, the President's office basically said that they would not consider this a policy again, and they wanted another office to actually house these guidelines. And probably for about close to a year, our VP research was resisting having these guidelines under the REB office. I think because she felt that then we would be contacted, we would be looked upon as the experts in quality assurance, where essentially we were not. Unfortunately, we lost that arm wrestle, and these guidelines are now under our website under policies, although the first sentence is that when you go and look at these guidelines, it states, this is not a policy. But they're there. Okay. So I'm going to focus again on why are we looking at the relationship, and that the relationship can be why is something QA and research. So this is what I think is sort of the olden days. This is how we're looking at things now. And this is kind of this map where there's a lot of intersecting pathways. So in many cases, QI activities and research are not separate. And I think a lot of it has to do with the university being a major driver or a major influence of this. And I think some of these will be familiar to you. So in looking at the context, let's start with academic programs first. There have been a lot of what I would call QI, QA focused projects that are being used to fulfill academic requirements at UVic. They come in the form of theses, dissertations, and capstone projects. So, you know, these two faculties and schools have used a lot of evaluative projects, and students are doing evaluative projects to fulfill these requirements. These other schools there, particularly public administration, I think they're our highest user of REB review, and the other ones as well, because the projects are doing very practical, evaluative types of projects. Oh, something didn't go. Okay, so what are the characteristics of these programs? We're finding that a lot of programs at UVic, and I'm thinking at Camosun here, and likely at UBC, they're what I would call professional, project-driven programs. So these are usually students who are coming in as mid-career professionals, and they continue to work in professional capacities all over the world. And so the academic programs are trying to attract those kinds of students more and more. We have a lot of what I would call client-driven projects. So this is when a student works together with either an NGO or an organization, an industry partner, an external partner to build a practical project that will be of use to that partner and also be a learning opportunity for themselves and fulfill their academic requirement. These are the ones, I call them impromptu opportunities. At UVic, we have a large co-op program, and UVic student population right now it's probably close to about 24,000 students. And about 3,000 of those students every year participate in co-op programs and practicum placements. And so what we see is that when students get into these programs, they look around and they think, these are excellent opportunities to actually conduct a project. And I'm going to conduct a project to fulfill a requirement. It might be a requirement for a program that they're in now, or it might be a requirement that they're anticipating they can use the information to fulfill later. And that's, I think, one of the kind of scary parts for a lot of REB people, because we don't know when these opportunities come up until they're presented to us. So these kinds of programs and projects creates a lot of complexity, and on a bad day, I would call it creates a lot of confusion for people sitting in REB offices. They create what we call embedded or dual role researchers. So these are the professionals. They may be nurses or students, teachers, or people who are working in their professional capacity, and then they're actually doing some kind of project within that professional capacity at a hospital site or a school or another institution. So that's what we call our dual role researchers. And we see a lot of these kinds of researchers and students in those programs. And these dual role researchers create, again, multiple purposes for a project. There's the objective to fulfill an academic requirement, and also to provide feedback, final reports, assessments to the sites or those locations who are working with them or who are actually employing them. Okay. We also are seeing interesting differences between QA and research, especially when now UVic is part of the BC Ethics Harmonization Initiative, where someone will be a professional working at a hospital, and that hospital will say, you're doing program evaluation, therefore there's no need for you to have an REB review. And yet that same person will have a foot in the academic institution, and they're actually using that experience for their academic requirement. So this has created really interesting kinds of complexities and actually made them more complicated by the fact that we're having to deal with our institution and another institution whose operational definitions may not match ours. So again, these are the contexts that we've been working in. Okay. We also find that campus service units are a really popular place for these kinds of research and evaluation projects. I've listed some of them there. And many of them use the same kinds of scholarly approaches. So people are studying with the intent of research, but also the intent to improve whether or not it's child care delivery services or health services, or even about the kind of teaching that goes on at UVic. So I'll give you some interesting examples to show the conflation between these two. So one of the projects that we've been able to support at UVic is something called the PIT project. And this is run out of Student Health Services by a psychiatrist called Dr. Marilyn Thorpe. So her goal of this project was to reduce the wait times for mental health access by students. So in doing this project, I remember meeting with Dr. Thorpe and her team, and I remember saying to them, you know, your goal is to reduce the wait times. So I said, this could be pretty much a program improvement type of study. Why is it that you would like to seek REB approval? And I think that, as I recall, the team was saying, well, there was a lot of academics on this team, and they wanted to use that experience in a way to be able to share that and to be able to look at that through sort of scholarly lenses. There was also a grad student, and I think they wanted to be able to use that information outside the university to actually share it with other universities and other mental health units at other universities. And they were actually able to lower the wait times for students. I think it was from 43 weeks down to 23 weeks. That's what they were able to do when using what they call PIT crews. So the student would meet with a group of professional healthcare providers when they came in, rather than being passed from one healthcare provider to the next. Okay. This is another great example of research and as quality assurance. Dr. Bernadette Pauly does a lot of evaluation work. This particular one, the managed alcohol programs, I don't know if this is also a UBC shared one. It might be. Does it sound familiar?
That acronym does not, I mean,
Yeah.
we have a lot of programs like this, but I'm not sure this one
I think
overlaps.
this one did come.
Yeah.
Map sounds familiar.
Yeah.
Maybe an acronym.
So this is a large cross-Canada study with lots of other collaborators. And again, they're trying to look at the best ways to provide and support managed alcohol programs while studying them. And then this last one here, PJ Naylor from the School of Exercise Science, Physical and Health Education. She's very involved in an initiative of the provincial government that's called Action Schools BC. And as part of the delivery of this large initiative, her team also is very interested in evaluating that. So a lot of that is involving focus groups, meeting and document review as the program is being rolled out so that they can learn and integrate that learning within their projects. Okay, so what is the role of the REB office in all of this? Normally, we're the first point of contact at the university, either us or sometimes institutional planning and analysis. And on our website, we now have these 3 questions to hopefully guide researchers into thinking about whether or not they do need REB approval. We continually try to monitor academic programs and research, and we try to have regular dialogue with all of those different entities on campus. Luckily, we're all in the same building. So privacy, institutional analysis, and the ethics office, we are in the same building, and we're able to sort of check back with each other as far as whether or not something is research or it's not, and what do we do with it. We've considered looking at different tools in the REB office. One of them is the Inertia tools from Alberta Innovates, which is very helpful, and also working with our great colleagues from other REBs, because that's where I think the sharing of best practices happen, even though some of those institutions, like health authorities, are extremely different from our own. Okay, so here's what at UVic right now, version 2017, this is generally what we say will require an REB review. So if someone is carrying out an activity involving humans for fulfilling a program or a course requirement, any degree kind of program, we also want to think proactively. So we ask that individual, well, what about future degrees or future grants? So they may be completing or doing a evaluative activity now, but are they thinking in the future of using that information? Because as we know, if you don't have REB approval from the beginning, it's almost impossible, or I would say very difficult, to come back or to show up at another institution and say, I've got this information, now I want to use it in this program or for a program of research. So we're also looking at, is there an intent to share that findings outside the university? In some cases, believe it or not, some people come to us and they say that they really want to have an REB review. It doesn't happen very often. And when it does, we're very surprised. And I think that the main reason that people have given us in those cases is that they want to make sure that there's been an arm's length review by another body within the university. And I think that would give that program evaluation some credibility and so a different lens that people would look upon it with. And some other granting awards and conditions that we see may be used to determine whether or not an REB review would be needed. Okay, so we have a very simple determination process. This is the question that people always, the statement that they say to us, I have a quick question, and they think that we can answer it in yes or no. But as we know, that quick question is very, very layered. And being in an institution, I think an REB office really knows that when people come to us, they don't always know what they don't know. So that simple question can lead to many layers of types of questions. So what we do is we request them to provide something in writing to us. And our chair or vice chair and one of the administrators in the office, we deliberate about it and we post questions back to that individual. So it's all documented. And then we provide a result communicated by email. That's just what we've set up over the years to make the determination and discussion process, I guess, doable within the workload that we have. And sometimes we have to meet with people to do that. Okay. So just in closing, I think that we recognize that human research ethics within a university context, the work that we do is linked, whether we like that or not, to all these other entities within the institution. We've got that public external community, we've got the academic structures, we've got other administrative structures that include grants and teaching. So we like to think sometimes that we are the center of the universe. But really, when all of those elements within the university change, we have to be part of that change. So the work that we're doing is constantly evolving, and we're also no longer just within our own institution. We're starting to work with other institutions because, and I haven't got into that, but because more and more research is multi-jurisdictional. So whatever processes and ways of addressing things that we do or have been doing, they have to be continually adjusted because really research is more about also working with other institutional players out there. So thank you very much.
Could you summarize the questions when we get just
Sure,
help the
okay.
microphone?
Yeah.
Well, I have a few questions. So when I think this happens quite often at Langara, and it happens at other institutions, where somebody is tasked with what's a QA/QI program, and they think, you know, this would get me a postgraduate degree that might be useful, you know, so that, you know, they then apply to a program and say, we're doing a QI study of leadership at Langara. Can I apply to your master's program, right? So the conception of it is completely QA/QI. The purpose of it is really QA/QI. This is a program requirement now. So one thing to say is, okay, because it's an MA, it's scholarly, and but I just wonder if there's any room to think of this. And I honestly, I think we struggle with this question. You know, could the REB not say in that situation, this is QA/QI, right? If you decide you want to use it for a scholarly purpose, to publish in a journal or to disclose at an academic conference, could it be treated then as secondary use of data, right? Then, you know, falling within TCPS. So it's just a general question I have. because it's an issue that we navigate from time to time. So anyway, I'd just be interested in your comment on that. You don't have to give a definitive answer, but it's a puzzle, I think,
Okay,
right?
so let me try to repeat the question. So your question was, I guess, how can REBs address projects that are QA and QI, especially through the lens of secondary data or secondary
yeah, I mean,
use, or is that a possibility?
Yeah, is that a possibility? And then
Yeah.
the context would be, it is, the entire purpose of it, for the individual is QA, QI, except they're now getting a degree out of it, or a diploma, some sort of program recognition. And then, but it's possible, right? So the question is, does that then necessarily make it research? And if it doesn't, then maybe you can treat the data when the data might still be useful for other purposes, and then the REB becomes involved when it becomes in effect secondary use of data. I think you summarized it very well, the issue. But
Yeah, I think I can address that in two parts. One, in the practical sense that, we know that, for example, when we receive applications from specific schools and programs, it's very clear to us that the purpose out in the field or the community is QA and QI for a client. So what I think how we've handled it is really how we assign and look at proportionate review. We do review it, but we review it at the most, a very minimal level of review. And then by doing that, we've enabled that student to then be able to use it for hopefully other purposes and in other contexts later on. I'm glad you asked about secondary data and secondary use, because that is it's fascinating and it's very, very slippery. And where we've seen it come into play mostly is what I would call the impromptu opportunities to conduct research, where someone is in a placement, a co-op, or they're actually in their job. And they're looking around and they're thinking, wow, I am actually, I have access to this kind of information. Maybe it's health information. Maybe you're a healthcare provider. And then you would actually like to use that information. So let's just say if I took the healthcare provider part out of the equation for now, I think it makes the, for secondary data, our understanding that this was information that was collected for a purpose that was not research. So for us, there's a time separation involved in that. So that time is ended, information was collected, and then time goes forward, someone finds themselves within an academic program and says, now I would like to use that information. So that's one example that is generally quite straightforward for an REB to address. I think where we have found it very difficult is when that time is continuous and flows into the academic program and the REB potential review, where we've had people who've contacted us from in the field. They say, I am now working, I just started in this co-op program. I would like to use this information because in 2 months' time, I'm starting an academic program. And so I have all this great data around me, and now I would actually really like to use it. So what we try to do is we try to stop that process, and we try to provide that student or that individual with instructions to actually have an REB review, so that there's no danger and there's less complication for them to be able to use that information. it's maybe not exact, but I think it's a mechanism or a way that we've tried in order to, in the best possible way, support researchers, support students, so that they don't get tripped up in trying to then figure out with the REB, how do we try to acknowledge a sort of retroactive process.
I think one of the areas that we are experiencing that in right now is in the scholarship of teaching and learning initiatives, because they are, I mean, the actual learning environment is very much about collecting data on an ongoing basis. And they're grappling with it as well, and have been very proactive in trying to figure out where the research ethics piece fits in their daily practices. But it is another one of those examples where a graduate student will find themselves with a body of data, and suddenly a research project emerges out of the data rather than them designing the research project and then seeking the data. It's almost like it happens in reverse order.
And I think that does happen. Like, my scenario about it is that it's the graduate student coming into their program with their suitcase of data. And in talking to past REB chairs and vice chairs that we've had, there are some departments that will not allow that. They will say that the reason that student is in the program is so that they can be trained in actually designing the study in a way that meets sort of scholarly levels. I mean, we can still talk about secondary data, but then again, you know, we don't really know where have permissions been in place for that suitcase of data, and where did it come from?
I'm afraid we have to stop. I invite you to ask questions of Eugenie out in the hallway. I would like to thank you, but also commend the work that the REB is doing in Victoria on these issues, which I think are really complex. And actually, I would be delighted if you would let us know what your guidelines are, or what you tell us informally written about this question around secondary use of data for reasons. That'd be terrific. So thank you very much.
Thanks.